Thank you for taking the time to listen to this short presentation. By way of introduction, my name is Myrne Reedy and I'm a Senior Associate in Dillon Eustace's Regulatory Investigations Unit. For the next couple of minutes, I'm going to give an overview of market abuse investigations which can be carried out by the Central Bank of Ireland, as well as the sanctions which can be imposed. I suppose market abuse is a somewhat topical area at the moment, given that a few US senators have come under scrutiny for significant share sales they made just prior to the coronavirus pandemic crashing the markets. In this slide, I've just mentioned some key legislation in the area. You have MAR, the Market Abuse Regulation, the Directive on Criminal Sanctions for Market Abuse. There's also the Irish regulations, which are the European Union Market Abuse Regulations, and then Part 3 of the Central Bank Investment Market Conduct Rules. Before I go on to look at the administrative sanctions which can be imposed under Part 5 of the Irish regulations, I think it's worth mentioning that under Part 2 of those regulations, criminal sanctions can be imposed for certain market abuse breaches, and the Central Bank can actually bring summary criminal prosecutions for those offences. However, for the rest of this presentation, I'm just going to look at administrative sanctions which can be imposed under Part 5 of the regulations. So administrative sanctions can be imposed where there's been a prescribed contravention of MAR, and those prescribed contraventions are listed at Regulation 34 of the Irish regulations. Administrative sanctions can also be imposed where there's been a breach of Part 3 of the Investment Market Conduct Rules. I think an important feature of this particular regime is the fact that the Central Bank can actually sanction entities which wouldn't otherwise be authorised or regulated by it. So for example, issuers of financial instruments, which might be public limited companies, or an emission allowance market participant. And it's actually used this power in the past where it fined C&C Group plc and Icon plc for breaches under the old market abuse regime. Similarly, the bank can also sanction individuals who aren't involved in the management of financial services firms for certain breaches, such as people discharging managerial responsibilities and people closely associated with them. So what are the prescribed contraventions then? I've listed them on the slide, and some of them include insider dealing, market manipulation, failure by a person who is professionally arranging transactions and orders to have effective systems and controls in place to report on suspicious transactions, and failure by a person discharging managerial responsibilities or a person closely associated with them to inform the Central Bank promptly of any transactions conducted on their own account where these exceed the de minimis threshold. I'll mention it later, but the Central Bank has mentioned that this year it will be focusing on relevant entities' ability to recognise and manage inside information, and also to report on suspicious transactions. Then, aside from breaches of MAR, administrative sanctions can also be imposed where rules made under Section 1370 of the Companies Act 2014 have been breached. At the moment, the only rules that have been made under that section are the Investment Market Conduct Rules, and Part 3 of those rules deal with market abuse. So moving on then to look at how the investigation process works. Where the Central Bank has reasonable grounds to suspect that a prescribed contravention is being or has been committed, it can appoint an investigator to look into the matter, and that investigator is referred to as an assessor in the legislation. The person who is subject to the investigation is referred to as an assessee, and the assessee can make written and oral submissions. When an assessor is conducting an investigation, they have various powers open to them under the Irish regulations, and these include the power to require witnesses, whether they're based in Ireland or abroad, to give evidence under oath, and also to produce documents. At the end then of the investigation process, if an assessor concludes that a prescribed contravention is being or has been committed, an adverse assessment will be issued, and in that the assessor can set out any sanctions which he or she believes should be imposed. The Central Bank will then give a copy of the adverse assessment to the assessee. Assessees can appeal an adverse assessment to the High Court. Generally, they have 28 days to do that unless the High Court agrees to extend that period. Interestingly, the Irish regulations actually say that the Central Bank may apply to the High Court to have an adverse assessment and any sanctions imposed under it confirmed. I suppose the word may might be used to cover the situation where the Central Bank has entered into a settlement agreement with another party under which they've agreed to accept the imposition of sanctions, and to obviate in that situation the need for it to apply to the High Court to have those sanctions confirmed. So in terms of sanctions that can be imposed then following an adverse assessment, I've listed some of them on these slide, and these include everything from a private caution or reprimand to withdrawal and suspension of authorization of any regulated financial service provider. The bank can also disqualify an SSE from being involved in the management of or having a qualifying holding in a regulated financial service provider for a certain period, and require the SSE to pay up to 3 times the amount of the profits gained or losses avoided because of the breach, where this can be determined. Fines are also another potential sanction, and I've listed them on this slide. And the amount of fine which can be imposed depends on the nature of the particular breach, as you'll see here. So for insider dealing and market manipulation, for example, individuals can be fined up to €5 million and legal entities up to €15 million, or 15% of total annual turnover in the preceding business year. And then at the other end, for failure to draw up or maintain insider lists and breaches concerning managers' transactions, an individual can be fined up to €500,000 and a legal entity up to €1 million. So how does the assessor then come up with particular sanctions? Well, Regulation 42 of the Irish regulations sets out some sanctioning factors, and these include things like the gravity and duration of the breach, the degree of responsibility of the SSE for the breach, level of cooperation given to the bank and the assessor in carrying out the investigation, and any remedial actions taken. The default position is that the central bank will publish details of sanctions on its website following an adverse assessment, but there are some exceptions to that general position. Now, I mentioned a few moments ago that the central bank can enter into settlements to resolve suspected market abuse breaches, and that's provided for under Regulation 49, which says that the bank can enter into settlements at any time before an assessment has issued. Now, there's actually no guidance in the Irish regulations as to the settlement process to resolve suspected market abuse breaches, but the central bank has entered into 6 settlements for breaches under the old market abuse regime. 4 of those settlements were with entities which would not otherwise have been authorised or regulated by the central bank, and the fines imposed ranged between €5,000 and €90,000, and all of them were published on the central bank's website. I'm sure a lot of you will be aware that in January of this year, the central bank issued a Dear CEO letter, and in that letter it said it'd be devoting considerable supervisory resource this year to examining compliance of regulated entities and issuers with their obligations to recognise and manage inside information, and with compliance by relevant regulated entities to identify suspicious transactions and orders. So while there hasn't been a fine in this area in a few years, it obviously is an area that the central bank is paying particular attention to. And I suppose that highlights really the importance for relevant firms of having effective market abuse policies and procedures in place, which their staff are trained on, and also to ensure that staff are aware of the legal obligations which are imposed on them. So that brings me to the end of this short presentation. Thank you very much again for taking the time to listen. If you have any queries on market abuse investigations by the Central Bank of Ireland, please don't hesitate to give me a call or to get in touch with another member of the Regulatory Investigations Unit. Thank you very much.